Section 21 requires one of the parties to a data sharing agreement to be designated as the lead agency responsible for carrying out the functions specified in this section and elsewhere in the bill. In relation to data sharing agreements, it sets out a number of functions that the lead agency will have. Some of these functions relate to the control of the data under the GDPR. Subsection 4 provides that a person can direct requests to exercise their data subject rights to the lead agency. Subsection 6 of the section was included on foot of an amendment proposed in the Seanad. It provides that this section is without prejudice to and does not limit the rights of a person as a data subject in respect of any or all data controllers in a data sharing agreement. I accepted the amendment in the Seanad because I and my officials believe it simply reinforced the position that under the GDPR a person has the right to direct requests to exercise their data subject rights to any of the data controllers in a data sharing agreement. Subsequently, the Attorney General's Office have raised concerns regarding the subsection. The concern is that the wording, which is, quote, "this section is without prejudice to," introduces legal uncertainty as regards whether the data subjects would have full access rights under the GDPR in respect of any data sharing arrangements made under the legislation. It implies that there is prejudice elsewhere in other sections of the bill, and it's on that basis that I have sought to amend it. The Attorney General's Office have advised that this provision should be deleted because the inclusion of this subsection brings about unnecessary doubt as regards the hierarchy between A, firstly, rights under the GDPR not referred to in Section 21, subsection 6 on the one hand and Section 6 on the other, and B, secondly, rights under the GDPR referred to in Section 21(6) on the one hand and other sections of the bill on the other. I withdrew this amendment to committee stage so as to have an opportunity to explain the advice I have received from the Office of the Attorney General to the House. I thank the members who met myself and the members of my officials from my department for their constructive engagement. The policy intent is that no rights under the GDPR and the Data Protection Act of 2018 are to be affected by this bill. This is already achieved by Section 6, which provides that nothing in this Act shall affect the operation of data protection law, and by the doctrine of supremacy of European law. Accordingly, I am asking that the provision be deleted rather than cause any unnecessary uncertainty for citizens, and I ask the House for their support.